The nomination of Judge Ketanji Brown Jackson will make history. She'll be the first African-American woman on the court, and she'll move a court that had never had a woman member when I started practicing to a court where 4 of the 9 members are women. What powerful evidence of the capacity we have as a nation to come closer and closer to the equality ideal that was articulated as our moral North Star in the opening phrase of the Declaration of Independence drafted by a Virginian in 1776. So I celebrate the history-making nature of this appointment, but it's not the reason for my support. I support Judge Jackson's nomination because of her stellar academic credentials, her prestigious judicial clerkships, her dedicated service as an attorney and member of the United States Sentencing Commission, her well-respected tenure as a federal trial and appellate judge, and the multiple attestations that she has received attributing to her fairness and to her character. Mr. President, in particular, I think that her successful confirmation as a justice will add 2 critical skill sets to this 9-member collegial body. First, that she's a public defender, and second, that she's been a trial judge, that she was a public defender. So much of the court's docket deals with issues that are at the heart of the American criminal justice system. And there are currently members of the court, Justice Sotomayor, Justice Alito, Justice Gorsuch, who had experience as prosecutors in both the state and federal courts before they began their service in the judicial branch. That experience as prosecutor is really important experience, and it's an important expertise to have on the Supreme Court. But a Justice Ketanji Brown Jackson will be the first public defender ever to sit on the court. And for a court of 9 to share perspectives and grapple with resolution of questions involving the criminal justice system, for that court only to have people who've prosecuted cases and not have people who have defended, in particularly the most indigent criminal defendants, it's a court that doesn't have the balanced 360-degree perspective that we would want in these important matters. So the fact that she served honorably as a federal public defender, in my view, is a strong trait for her, but it's even a better trait if you think about what we would need in a 9-member Supreme Court. Second, she's been a trial judge, a federal district court judge in the district court for the District of Columbia. And that is really, really important. There's only one other member of the court now who is a trial judge, and that's Justice Sotomayor. Some of the members of the court, as far as I know, I can find no evidence. Not only were they not trial judges, there are some who I'm not sure ever tried cases. What does it mean to have a trial judge on the court? Well, again, think about the docket of the Supreme Court. So much of the docket of the Supreme Court is ruling on questions and controversies whose ultimate goal is to make the nation's trials, civil and criminal trials, more fair. Admissibility of evidence, sentencing standards, definitions of police misconduct that could either gain or shed sovereign immunity in a trial going on in a trial court. How to impanel jurors, how to instruct jurors, when to strike a juror if there's evidence that the juror may have a bias or prejudice. These are all cases that come before the Supreme Court all the time, and these kinds of cases are particularly important to have a court that is well represented by people who've actually been in the courtroom and done it. What trial judges have to do is they have to figure out how to instruct and impanel jurors and deal with the juror who may have a bias question. They have to rule on evidentiary objections in a split second, dispose of discovery disputes, rule on dispositive motions like motions to dismiss or summary judgment motions. In bench trials, actually render judgments, which usually involves credibility determinations among competing witnesses. The judges in the federal system are those with the power of sentencing, the most difficult power of all. If you have not been a trial lawyer or a trial judge, you might underestimate how difficult and challenging each of those tasks are. But if you've had the experience of being a trial lawyer or trial judge, you understand how important they are. I asked Judge Jackson as I interviewed her, tell me how you think being a trial judge might help you on the court. She said so much of our opinions are essentially instructions to state and federal trial courts. Here's how to conduct a fair trial. I think my experience will enable me to write opinions that are more workable, that are more understandable, that are more practical, that are more likely to lead to a result that is fair to the parties, but also one that will increase the respect for the decision-making in courts themselves. When I was governor of Virginia, Mr. President, I did not have the power to put judges on the bench, except in rare instances. In Virginia's state system, I wouldn't even nominate judges. The legislature would choose the judges. And the governor had no role except when the legislature would deadlock. If the House and Senate couldn't agree on filling a position, then the governor got to put in a judge or justice until the legislature came back next year, and then they would have to vote on whether to ratify what the governor had done. 3 times when I was governor, my 2 Republican houses deadlocked on an appellate judge, 1 on the Court of Appeals and 2 on the Virginia Supreme Court. And so I had this opportunity, as somebody who practiced civil rights law for 17 years, as somebody who was married to a juvenile court judge, I had the opportunity to consider and then nominate people to be appellate judges. And I decided pretty quickly as I analyzed who should be appellate judges, and I followed this rule in all 3 of my opportunities, I would appoint a great trial judge. In each of the 3 instances, I appointed a great trial judge because I knew that that great trial judge would be able to sit on an appellate court and render rulings that weren't sort of philosopher king or queen rulings that might sound good in a law review article or in a panel discussion, but they could render rulings that would be instantaneously understood in courtrooms all across the Commonwealth and able to be implemented by the other trial judges who are doing their best every day to conduct fair trials. And so that's why I think the second factor, that Judge Brown Jackson was a district court judge handling trials, multiple trials and motions every day, will put her in such good company as she joins Justice Sotomayor as the only other member with that experience. I'll conclude and just say a Justice Ketanji Brown Jackson will add depth and perspective to a court that needs it. As we near the 150th anniversary of Myra Bradwell's quixotic case, the confirmation of Justice Ketanji Brown Jackson will make the statue of justice and the engraved phrase, equal justice under law, more accurate reflections of our nation's highest court. And with that, Mr. President, I yield the floor.